It's the South Carolina Good Life Podcast.
Hey, good afternoon, Realtors. Byron King, General Counsel, South Carolina Association Realtors. Welcome to the Good Life Podcast. It's August 9th, and 2021 information is good today. We got the three SCR attorneys. Our hotline number is 803-772-5206. We'll be discussing the top 10 ways that you can have an ethics complaint filed against you. Thanks to Mike Chris doing all the video production. Thanks to Alan Lightly who compiled this information using 2021 ethics complaints. And I'll let Austin, why don't you introduce yourself, please?
So I'm Austin Smallwood, the Director of Legal and Regulatory Affairs with the Association. Also serve as staff liaison with our ethics process, both with grievance and professional standards.
Super. And Tiara, introduce yourself, please.
Hi, I'm Tiara Pitts. I'm a part of the legal team with Austin and Byron, and I'm also the Director of Fair Housing Policy here at SCR. I serve as the staff liaison to the Diversity Committee as well.
Super, thanks. And so what I'll do, I'll introduce we'll do a top 10 countdown, kind of like David Letterman used to do, and then I'll ask you guys to comment on some of your hotlines and ethics cases. Austin handles ethics, so he can focus in on that, and forms, and Tiara can focus in on some of the fair housing issues that we've seen. So number 10 was a tie between Articles 5, 8, and 11. So Article 5 is kind of self-dealing and disclosing your self-dealing, self-interest in transactions. And we'll kind of just we'll start with Austin first since it's ethics. We'll let you talk about Article 5. What are some things you've seen with Article 5, Austin?
Yeah, so the most common thing you see with Article 5 is where you have a separate business outside of real estate and you don't disclose that to parties, whether that be that you do photography, landscaping, staging, something to that effect, and you tell a seller or buyer, hey, I have this service that I can use to help you, and you don't disclose that it's you or your spouse. It's fine if you have that business, but you just want to go ahead and disclose, hey, I've got this business that can be of assistance to you, but here's also the number of 2 or 3 of my competitors. Go ahead and get the best quote for you, but don't do any sort of sleight of hand there. That's probably the number one issue we've seen on Article 5. As well as when you do a BPO or a CMA, if you're interested in buying the property, it's probably inappropriate for you to be doing that for a seller.
Yeah, good points. And Tiara, what have you heard on the hotline on some of these issues? Any kind of self-dealing, wholesaling, flippers? What have you heard?
Yeah, I've got some calls about people that maybe they have like a painting company and they just want to make sure they're disclosing everything and doing everything by the book. So like Austin said, in that case, it's not that the person can't use your service, but you just want to make sure you're giving them other options and that they're going with who they want to based on, the prices or whatever else.
Yeah, good points. Another thing I bring up a lot of times is make sure you have that discussion with your broker too. Make sure they're aware that you have some sort of side business going on and that your brokerage is on board with that. This is a tie between Articles 5, 8, and 11. So Article 8 is earnest money. Austin and I, this has been kind of our number one call over the years. But Austin, we'll flip this. We'll let Tiara go first on earnest money. Tiara, what's some of your hotline calls on earnest money?
So earnest money was really the first topic that I got comfortable with because it's pretty simple. The only way that earnest money is going to be able to be released is by that mutual agreement by the parties, and we have Form 518 for that, or from a court order from a judge with competent jurisdiction. So sometimes people think, the deal went bad, I'm entitled to the earnest money, but it doesn't necessarily go that way. So it's important to get an attorney to draft up an escrow agreement, which can help kind of deal with some of these issues because, the money isn't just going to automatically go to one party or the other, which is a big misunderstanding that I've been getting on the hotline. People think that they're entitled to the earnest money just based on whatever happened with the deal. If something fell through, they feel like they should get that earnest money. But it's never quite that simple because it's always two sides to everything.
Yeah, exactly. Austin, what are some of your hotline calls on earnest money?
Yes, the way I usually teach this article is that because it's Article 8, you sort of think that it's the magic 8 ball. If you scratch on this one, that is the end of your real estate career. The Real Estate Commission also would have jurisdiction on this, so making sure you're not commingling any sort of funds. You're aware of whether you're a licensee or a broker in charge, what your requirements are under statute for getting earnest money to the appropriate place. Sort of kind of say once you get that money, it needs to go immediately to the proper source. Don't lose it. Don't commingle funds at all. that will be an automatic revocation of your license.
Oh, that also reminded me, make sure that when the earnest money is getting deposited, that you're getting some type of receipt or confirmation that that earnest money is where it's supposed to be, because I've been seeing instances where the earnest money never ends up in that escrow account because maybe one party stopped the check or something like that. So you want to make sure that the earnest money actually gets where it's supposed to be and that you have a receipt of that.
Yeah, that's a great point. So earnest money, some things I get on the hotlines, the buyer's agents think that once a deal falls apart, that the seller can't go ahead and resell their property when the earnest money is in dispute. So Forms Committee updated the release form, SCR 518. Austin, you worked with Forms Committee. What was some of their thoughts on updating the 518?
Yeah, so we now have an option in the release agreement that allows you to cancel the contract, but essentially say we're still disputing the earnest funds, and we are now going to direct the escrow agent, whether that be the buyer's broker, seller's broker, or law firm, to disperse those funds. So you've had that call. We've gotten the call on the hotline where, hey, the buyer wants to buy a new house, the seller wants to sell somebody else. They are never going to go to closing on this, but they're still disputing the earnest money. So now you can select that option 4, and then present that to the appropriate escrow agent and ask them to file that interpleader.
Yeah, that'd be a good change, I think, based on hotline calls. Earnest money, like Tiara was mentioning about interpleader. So magistrate interpleader, the broker in charge can volunteer to sue a buyer and seller under magistrate interpleader. Remember, the jurisdiction limit for a magistrate judge is $7,500, and our state contract, SCR 310, also allows the escrow agent to say that the parties will pay them a certain amount of money before filing the magistrate interpleader. Or even if it's above $7,500, hiring a law firm to pursue a full-fledged lawsuit on interpleader, which is expensive for the escrow agent. So it was a tie. In number 10 was a tie between 5, 8, and 11. Article 11 is our competency article in the Code of Ethics. And we start with Tiara, so we'll let Austin take this one first. Austin, what are some hotlines you've seen with Article 11 about surveillance, protecting listings, competency?
The most common thing we see with Article 11 is really practicing outside of your area of competency. We kind of say a realtor in the state has something that they're very good at, whether that be residential, commercial, land, property management. It doesn't mean that you can't do multiple, but you need to be competent in what you're doing there. So if you've never done a commercial deal your entire life, you probably aren't the best agent to represent Walmart. If you have only done commercial, you probably aren't the best person to represent a new homeowner. And then we're seeing more and more where you'll go somewhere you're not familiar with in the state. So you've only lived in the upstate or on the coast your entire life. You probably aren't the best person to represent, a friend or a new client who's wanting to buy a mountain house if you're from the beach, or a beach house if you're from the mountains, because there's local jurisdictional stuff you may not be aware of. So that's where the referral agreements are probably the best solution there.
Fantastic. Tiara, what are some hotline calls you've gotten on Article 11 about competency, protecting listed properties?
Basically just the same thing Austin said, just making sure that if you're not competent, that you can get competent. And if you're not the best person for the deal, it's nothing wrong with referring that out to another agent and having some type of referral agreement.
Super. And thing I've seen lately is short sales are starting to come back. We haven't seen those since the recession. So a lot of agents that have only been in business during the good, strong years in the real estate industry might not be familiar with short sales. So referring somebody or even associating somebody in your brokerage to help you as you kind of learn on the job and read everything you can online about the topic to get competent. Talking about surveillance, protecting listing properties, Nick tweeted this week that as many as 1 in 3 properties have surveillance in them. So make sure you're behaving in listings and protecting listed properties. And moving to number 9 in our top 10 list, number 9 is Article 16. So that's interfering in an agency or non-agency relationship. And then last we let Austin go first. So Terry, you want to take Article 16? What are some hotlines you've gotten about people interfering in other people's, particularly agency relationships is probably more common than non-agency?
Right. I actually had a call about this last week where it was a realtor, their family member came up to them at a family event and actually, they told them they're working with another agent, but they don't feel like the agent is doing everything that they can to sell their home, and was kind of wondering if they could switch over to the family member that they were familiar with, who was also a realtor. And the advice I gave was just, once you know someone has an agent, you're really not supposed to be discussing those deals with them. And some people don't exactly know if they have an agency agreement or, they're confused. So you just want to make sure that once you find out that person is represented by another agent, and you can maybe check that with the agent just to double check, then you want to make sure that you're not talking business with them at that point, because they are under the representation of someone else, and this is one of the big ways where you can get into a commission dispute later on.
Yeah, exactly. This is the gateway to arbitrations that we see. In Austin, Article 16, what are some things you see about interfering in other people's relationships with agency and non-agency?
Yeah, I mean, the biggest thing is when someone walks into your office, to make sure that they haven't been working with somebody else. Show them an agency disclosure brochure. Show them a listing agreement or buyer agency agreement. Say, hey, have you gone around with anyone? And if they say yes, then you kind of need to, honor that entire period of that existing relationship. If they're not sure, like as Tiara mentioned, it's not a bad idea to go ahead and call the other broker and just say, hey, I didn't get a clear answer. We don't want to kind of step on any toes. But once someone is in an exclusive relationship, you cannot interfere during that time period, and you can't do anything to entice that individual to come to your brokerage. Now, if someone voluntarily on their own comes to you and says, I'm not planning on renewing with my current brokerage, you can enter into an agreement with them that begins after that current agreement expires, or for a different type of service. But until that time, until your new agreement begins, you cannot talk to them at all. If they say, hey, I fired my agent, I want to get a release, you need to sort of say, hey, any questions about that need to go to your broker or your attorney. Do not provide them a lease agreement. Do not talk to them about it. Don't give them any advice on how to get out of their existing relationship.
Yeah, excellent points. What I say also is talk to your broker in charge and give the hotline a call, 803-772-5206. We can go over this issue, because a lot of times, like Austin pointed out, the buyer is trying to get out of that relationship, may be intent on firing their former brokerage, even using their attorney's advice. So you will have that issue come up from time to time. And number 8 in our top 10 is Article 10. So number 8 is Article 10, fair housing and harassment. Tiara is our Director of Fair Housing, has been giving classes around the state, and you can sign up to get classes. NAR has provided Fairhaven, an online virtual trainer, and implicit bias video training, and also offers the At Home with Diversity certification. And a lot of this was based on last year's Newsday. If you haven't seen the Newsday hidden videos with realtors making comments that were inappropriate for fair housing, you can Google Newsday, Long Island Fair Housing, and you can see some of those videos. And NAR has said that the number one way that most realtors get in trouble with fair housing, protect a class's disability, especially with service and emotional support animals. Tiara, I'll turn it over to you, since this is one of the things you've been giving a class around the state. Kind of give them a way to contact you about setting up a class if they would like to as well.
Yes. If you are interested in your brokerage or your local association, local board, having me come present a fair housing seminar, you can just email me at tpitts@screaltors.org, and we can set up a time for me to come out either in person, or I also allow that to be virtual. And basically that seminar just starts off with a little history about fair housing and why there was a need for fair housing laws. And then it brings it more current to the things like Byron was talking about with the Newsday investigation, which showed that people of color were getting unequal treatment, although they had the same type of buyer's power. They were getting treated differently. So that is a very interesting study. And the seminar goes through that, and it also goes through what you can do as a realtor to help with these issues, and how you can make a difference with fair housing.
Super. And then Austin, what kind of hotlines have you gotten in the past on fair housing issues?
Yeah, I mean, the number one thing we're seeing right now that's sort of new is love letters. So if you're not aware of what love letters are, that's good. Don't use them. Don't accept them. That is where a buyer, in order to make their offer more attractive to a seller, includes a letter that says, this is why we think this is the perfect house for us. It generally involves, their sort of familial status. This is a great yard for our kids. We really enjoy throwing birthday parties, things there. Just don't send those. Don't accept those. The seller needs to be making a choice based on an objective standard. So you're sort of, as a buyer's agent, if you submit those, you're really kind of in trying to entice a seller to commit fair housing. And if you present them as a listing agent, you're really kind of encouraging your seller. So I kind of also say these are not part of an offer. So if you do as a listing agent receive them, there's nothing wrong with not providing them to your seller. That's not failing to present an offer, but also kind of doing that. And then also, and Byron may be able to touch a little bit more on this, is clients Facebooking each other. So don't have, having sellers looking up or on social media, a potential buyer, or buyers looking up sellers. That's just not a good idea. Making sure that, again, all parties involved are making choices based on objective criteria.
Yeah, it's a great point. I've heard that on hotlines and NAR lawyer talks as well, that some listing agents will even hide the last name of the prospective buyers. They'll just call them like buyer 1, buyer 2, buyer 3 in a multiple offer scenario. That way they can't go out and stalk the people on Facebook and do their own kind of research on the person's name. And some names will give away different protected classes on some people depending on the last name or even the first name, male or female sometimes. So some listing agents, for fair housing reasons, shield that information from the seller and maybe even use a spreadsheet like Austin was talking about with the love letters, so that's just based on business decisions, so that the spreadsheet just has buyer 1, buyer 2, buyer 3, highest and best offer, puts in the price, maybe puts in if it's financing or cash, closing dates, all the appropriate things on the business decision making for the seller. So those have been some ways we've heard around the country that people are trying to insulate each other from fair housing violations. And number 7 in our top 10 is Article 13. This is the unauthorized practice of law. And I know Austin, when he gives his ethics classes around the state, he always goes into Article 13, so I'll let him lead off on Article 13.
Yes, this one's super easy. If you're not an attorney, don't practice law. That is a felony in the state of South Carolina. The way that you are most likely to violate Article 13 is by drafting of addendums. So that's what I kind of say is the punctuation rule. If there's something that requires punctuation in an addendum, that needs to either be reviewed by counsel or drafted by counsel before doing it. Because if something was to go wrong with the transaction, it goes to court and they go, well, who wrote, which attorney wrote this addendum? And you raise your hand, that could be a big issue there. So just making sure that you're not, drafting addendums, and then also pulling contracts. Don't Google contracts, especially don't use contracts from other states. Every state has different real estate laws. So even if it's a border state, say North Carolina or Georgia, their real estate laws are different than ours. And so using a North Carolina or Georgia form in South Carolina is not recommended or advised.
Super. And Tiara, what are some hotline calls you've gotten involving unauthorized practice of law or recommending legal counsel, Article 13?
Right. Sometimes I see that the realtors are trying to be agents for their clients, but sometimes they can be almost to the point of offering them legal advice, and we always advise against that on the hotline and advise their clients to call their own attorneys, because while we're attorneys for the agents, we're not attorneys for their actual clients. So it's just important that their client is getting their own counsel and just being made aware that these addendums, while they could just be a sentence or something small, they can have other legal implications. And like Austin said, you don't want to be held in violation for just writing in a sentence. You just want that to be really reviewed by a lawyer, and make sure you're referring your client out to obtain their own counsel and not trying to step into that role.
Yeah, good point. And so a lot of times people get a little bit upset with lawyers on the hotline when we say you've got to tell your client to obtain legal counsel, because they feel like we're trying to dodge the answer when they want to know who's in breach of the contract. And so try to remind them that under Article 13, they have an ethical duty to recommend their buyer or seller obtain legal counsel. And that the word counsel will keep the realtor from getting an ethics violation is kind of our job. So by telling your clients to talk to their legal counsel, we're not dodging the question about who's in breach of the contract, but we're protecting everybody involved, the buyers, the sellers, and especially the realtors, because they need to go to court if they're going to take it to the full extreme. And both sides would have lawyers and experts. They would argue all the testimony and evidence about who was in breach, and the judge would make a decision, and even that judge could be appealed. One thing that's come up on the hotline recently about using phrases or sentences or escalator clauses. So, Austin, with the Forms Committee, what are some issues you guys have talked about escalator clauses, escalation clauses in residential transactions?
Yes, we're certainly seeing more of escalation clauses right now. So the most common question we get on the hotline is, are escalation clauses illegal? They are not, but it is illegal as we go in over in Article 13 for you to draft one. So you either need to have, if your client wishes to use an escalation clause, one, explain to them the pros and cons of it, whether that your client be a buyer or a seller, and then say, hey, if you would like one, we got to do one of two things. We either got to have you go to your attorney and your attorney draft one, or our brokerage has decided to hire a brokerage counsel to draft one. SCR at this time does not have a standard escalation clause. It is something that we are aware of, but trying to find something that kind of fits everything has been sort of a challenge, because these things do tend to be very sort of narrowly tailored for a particular transaction. But if your client would like one, they need to talk to their attorney, or you need to have, as a brokerage, make a decision that we're going to have one that's available to our clients that's been drafted and reviewed by legal counsel.
Thanks for that update on the Forms Committee. All right, and then moving to number 6 on our top 10 of ways to face an ethics hearing panel is Article 3. This is kind of the cooperation article. Tara, I'll let you go first on this one about cooperating with other realtors. Ethics Article 3, please.
Yeah, we've been getting a lot of calls about this, and just, some realtors feeling like others are not really working with them, or, they're sending in offers and not getting that standard offer rejection form that is required back, or they're just, sending an offer and not hearing anything. So it's just important to work with your peers and your colleagues, because, we're all trying to work together here, and it's really important to just work together honestly and fairly, and cooperate, because that is, this is a big issue.
Super. And then, Austin, what are some hotlines that you've heard on Article 3 cooperation?
Yeah, the biggest thing with Article 3 is to understand that the obligation to cooperate does not necessarily mean an obligation to compensate. The most common way that this occurs is if your client is looking to buy a property in which you are not an MLS participant. Understand that cooperative commission that is offered in the MLS is for MLS participants. So if you live in the upstate and your client wants to go buy something at the beach and you are not a member of that MLS, you need to make sure that you're getting a compensation agreement, that's SCR Form 120, signed with that listing brokerage prior to your contract being being offered. Because what you don't want to do is go have your client be under contract and then be negotiating out your commission, because that is one of the ways your real estate license can be taken away, is fighting over a commission. So take care of the commission issue first, then present the offer. But that's the biggest thing, is if someone is not from, alternatively, if you have a listing, just because someone is not one in your MLS does not mean that you can restrict access to their property. You need to treat them the exact same. If your property is not available till Friday for people in your broker and your MLS, then it's not available for until Friday for everyone. But you do need to work out that compensation issue.
Yeah, good points all around. Reasonable showings, getting the compensation handled is definitely some top hotlines.
That actually reminded me of a call that I got where a person was going to a different MLS with the buyer client, and the agent on that home said that it would be like a $30 fee to get the key for that home. And I had to talk this over with Nick, and basically you're not want to restrict people's access just because they're from a different MLS. You are under a duty to work with them as you would people from your own MLS, with following the advice that Austin said about making sure your compensation is already handled.
Yeah, excellent point. And number 5 in our top 10 list, number 5 is Article 2 in the number 5 ways to face an ethics hearing panel. This is kind of the disclosure issue with latent defects, concealing property defects. So who wants to go first on this one? I'll let you guys pick. Who wants to go first on Article 2, latent defects, disclosures, concealing defects of a property?
Oh, I'll take it. So sellers are required to fill out a property disclosure, and that is South Carolina law. So you want to make sure that as an agent, you're informing your seller of that duty. Also, with the if you know a material or latent defect as an agent, you are under a duty to disclose that if you are aware of it. So it's just important that whatever you're aware of, it's going to have to be disclosed. And we tend to, on the hotline, err on the side of disclosure, even for some things that you may not necessarily legally have to disclose. People are probably going to find out, and then, if you go ahead and handle it on the front end, you won't have to worry about that coming back for you.
Super. Austin, what have you seen on Article 2 in your hotline?
Yeah,
types?
it's mostly the seller disclosure. A lot of clients get very upset about why won't you help me fill this out, or the expectation that, hey, it's actually the listing agent that fills out. That first page of the disclosure statement is actually a really good friend for you. So that actually lays out completely for a buyer and a seller what their obligations are, what your obligations are, and then as well as what potential recourse is available to them if something goes wrong. The recommendation we give is that seller disclosure, go ahead and give that to your client, your seller client, in a sealed envelope. That way, it's even more clear that, hey, I can't help you fill this out. I can't answer any of these questions for you. If you have any questions on this, you need to go directly to your attorney. I can't assist you with this form in any way, shape, or form.
Yeah, and disclosure protects everybody, because if it's disclosed, buyers can't sue the seller post-closing, and they can't sue the realtors post-closing if an issue's disclosed. On the hotline, I usually remind realtors that, you're not an inspector. You're licensed and trained and experienced in marketing real estate, so you want to recommend that buyers obtain all sorts of inspections. Let the buyers decide what inspections they want to pay for: engineering reports, surveys, home inspections, HVAC inspections, electrical, plumbing, everything that could be a part of a residential transaction. There's an inspector somewhere out there for that particular issue. So you want to recommend that the buyer obtains all of them, and let the buyer decide which ones they want to pay for and which ones they do not want to pay for as a liability limitation for yourself. And never, 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 ever say nothing's wrong with this house, because you don't know. Make sure that you recommend that the buyer gets an inspector, and let the inspector inspect the property and make a report and opine on the condition of the property. And number 4 on our top 10 list of ways to face an ethics hearing panel is Article 15. This is kind of our harassment article, saying false and misleading statements about other persons. And Tiara, your harassment is also part of fair housing, so I'll let you handle this one first. I'm talking about harassment or saying false or misleading statements about other real estate professionals.
Yes. So while we know that real estate is very competitive and you guys are working against each other, you do not want to be basically bad-mouthing other agents for ethical reasons, as well as that's not going to help you in your business, because you never know down the road, who you may have to work with. And I've had examples of this when someone would call and say, I had a call where a agent said their broker was actually telling a client that they weren't handling things right, and that they were, that they messed up a deal. And so basically the client wanted to leave that brokerage, of course, but, bad mouthing other agents is not going to help anyone. And, as brokers or leaders, if you see your client, if you see your agent maybe doing something that they shouldn't, try to talk to them first and handle that before you go out and, badmouth them or say anything, or make a Facebook post, or, talk about it online, because that's probably going to get escalated if it's handled that way.
Yeah, exactly. Especially social media, you can get in trouble really fast on that. Austin, what are some hotlines you've seen on Article 15, false or misleading statements?
Yeah, the biggest thing with Article 15 is to understand that does not simply apply to other members of the association, that it actually applies to real estate professionals. So that applies to non-member licensees, lenders, builders, closing attorneys, inspectors, essentially anyone you or your client is involved with throughout the transaction can fall under Article 15. So the other most common way we see this come up is a client asks you, what is your thoughts on this particular lender, inspector, builder, and you sort of just fire off and say they're not very good at their job. They're I think they're terrible. That's one that's could potentially a violation of Article 15 too. That's also not very helpful to the client. It'd be much more helpful to the client to explain, well, why do you think that they're terrible? Why do you have a bad experience? Was it did you have 5 transactions with this particular lender last year and none of them closed on time? Or if you've had issues with this builder where you've had multiple clients who've had issues after the fact, or delays, or whatever it may be, that information, and if it's based in fact, then you aren't going to be violating Article 15, because you aren't going to be knowingly or recklessly making false or misleading statements. You're going to be making a statement to your client that's based in fact.
Yeah, exactly. So truth it while it's defense. Somebody might argue about what is true, but having documentation to back that up is a good idea. And if you can't say something nice about somebody, it's probably best just not to say anything about them at all. And number 3 way to face an ethics hearing panel is Article 9. This is the article that says get everything in writing. Austin, since you're working Forms Committee, I'll let you handle this one first. What are some hotlines you've seen on Article 9, getting things in writing?
Yeah, so violating Article 9 is going to eventually burn you. So don't, negotiating via phone, via text message, via email, understand that's sometimes required with business, but that needs to be almost immediately followed with a, particular contract or addendum, because there actually is a clause in our contract that says, hey, the only thing that's binding on the parties is the four corners of this document. So just because two agents agreed, hey, the seller's going to leave the refrigerator, right? And they say, of course, they're going to leave the refrigerator. If that doesn't actually make it to the contract and the seller gets changes their mind the night before closing and decides to take the refrigerator, the buyer has no recourse because there was nothing actually in the contract to bind that seller. So having things in writing, making sure, of course, again, that anything that's in writing, that, if it's been reviewed, vetted by counsel, but, try to do as little negotiation via phone call, text message, email as possible.
Excellent. And Tiara, what are some Article 9 getting things in writing issues you've heard on your hotline calls?
I've saw issues where maybe an agent, the buyer's agent the seller's agent calls the buyer's agent and says, my client is going to accept your offer. But they never get anything in writing, and then, another offer comes and they choose to accept that. Agents are angry, saying, well, they agreed to sell me this property, but then I ask them, well, is it in writing? And they say no. So at that point, you don't have a contract until it's that mutual meetings of the minds and you have everything in writing. So while, it may be preliminary discussions and, you may have came to some type of agreement on the phone or in a text message, until you have it in writing, it is not official and it won't be enforceable.
Yeah, super. And we try to anticipate a lot of your written needs with our standard forms. So SCR 391, a lot of times realtors are not familiar with 391. That's the one with the standard clauses that are often used in transactions. You can actually just check box those. And Tiara mentioned Form 314. This is one that's kind of scary when we hear that realtors don't know about SCR 314, which is the LLR offer ejection form that since 2017 has been mandatory to send back to a buyer unless the seller has accepted or counter-offered on an offer. So 314, when we hear people don't know what 314 offer ejection form, that's very scary. And Austin talked about 518, the release being updated with the Forms Committee. Sometimes when it comes up on our hotline, there's two private MLSs in the state, in Hilton Head and Columbia, and those private MLS markets utilize their own forms. So just a reminder, you have to present all offers, but you would also want to let your sellers know, hey, I'm not familiar with this form. We need to get your attorney to look over this form, or maybe we counteroffer on a form that I'm familiar with. So call the hotline, 803-772-5206. All right, one of the last two of the top 10 ways to face an ethics hearing panel. Number 2 is Article 12. This is our false or misleading advertising. Tiara, what are some false or misleading advertising hotlines that you've heard in the recent past?
I've mostly been seeing things related to a name of a company. Maybe if the name doesn't quite reflect their actual name, that's on their license, then it can cause some confusion for the clients. And not having your brokerage, or if you switch brokerage and you still have your old advertisements, you don't want to do any advertisement that basically misleads or confuses the client, because that's going to be a way that they're going to file not only a complaint through us, but also with the licensing department. So I've been seeing that with just the names of companies and how you're putting your name, your brokerage firm on your advertising. Just be careful with those things.
Yeah, excellent points. Austin, what are some Article 12 false misleading advertising that you've seen on hotlines?
Yeah, so the two things I've seen the most of, first is listing property without authority, or advertising property without authority. And the way this is coming up most commonly is, Byron and I sign a listing agreement today, but Byron says, hey, I need a few weeks to get my house in order, so let's not even list the property until September 1st. If I talk about his property prior to September 1st, I'm advertising property that I don't have a legal right to advertise, because our agreement does not actually take effect till September 1st. So that includes someone who calls you about inquiries. I cannot put a sign in his yard. I can't talk about his property at all until September 1st, because if he, for some reason, decided to sell it to his neighbor on August 20th, then I've never had a valid listing agreement whatsoever. So that's the first way we see it. The second thing under Article 12 is involving where you're doing an advertisement where you give some sort of promotion or offer, so much in closing cost, or, a new refrigerator, lawn service, whatever it may be. Those are completely fine but you need to make sure that you advertise whatever conditions are attached to those offers. So if we're going to offer so much for closing costs, well, how much in closing costs? On what size property, for what length of time? If there's any other conditions, one of the conditions we always advise that you put on there is subject to lender and closing attorney approval, because if one of those two entities says that, hey, I'm not going to allow that promotion to be on the closing statement, then you've got an issue there. And of course, all that has to be disclosed on the closing statement. You cannot provide anything sort of outside of closing that's not on the closing statement.
Yeah, great point. So some things I've heard recently are photographs. Be careful about photoshopping. I got the classic example are the power lines that run right over the house, and in the Photoshop, the realtor has gone in and photoshopped those power lines out of the image. So a lot of people are buying sight unseen now, right? A lot of folks are from out of state, and there's a hot market, and they're putting in offers on properties that they may be relying on your photographs to make their buying decision. If they find out that you photoshopped some material defect out of the property, in their opinion, they may file ethics against you, license all complaints, and even sue you. And kind of related, make sure you have the copyright to photographs. Don't just pick off photographs off the internet or use the prior listing agent's photographs. So you might be facing a Article 12 or license law or even a copyright lawsuit. All right, and then drum roll, please. We got number one way that you can face an ethics hearing panel. It's easy to remember because it's Article 1. So the number one way is violating Article 1. It's kind of your honesty, looking out for your client's best interest. Tiara, I'll let you take Article 1 first here. Talk about some of the hotlines you've had on Article 1.
Right. So, yeah, I've had situations where a agent is actually leaving their brokerage, so they try to entice the client to leave with them, although they already have a listing agreement with that client under their brokerage. You don't want to do that. While if you have an agreement with your client under your brokerage, then they may be able to stay with the brokerage and just get switched to another agent. You don't want to make them feel like they're forced to leave with you if that's a decision that you have to make. And also, if you're leaving your brokerage, have an agreement in writing with your brokerage so that you know how your commission is going to go, and your deals that are already in the pipeline, you know how you're going to get paid for that. Because I've been seeing agents not having any type of written agreements with their brokerage, and you just want to make sure of that. And just being honest in your transactions, and not, you want to sell yourself as an agent and what you can do, but you don't want to oversell it to the point of dishonesty.
Excellent point, especially on a listing. When you go in on a listing presentation, you don't want to just say what the seller wants to hear. You want to be honest about what the property's worth, how you're going to list that property. And Austin, Article 1, honesty, client number one, what are some issues you've seen on your hotlines?
Yeah, so the two biggest standards of practice we see under Article 1 are 1.6 and 1.9. So 1.6 we sort of hit a number of times throughout here, but that's the requirement that all offers and counteroffers are submitted objectively and as quickly as possible. So it does not matter what form they're on, if they're even on a form. If they're on a napkin written in crayon, you need to get that to your client as soon as possible. And then any offer needs to either be accepted, countered, or that offer ejection form needs to be sent. And then 1.9 involves confidential information. So everyone sort of understands if you've got a client, information is confidential. But what gets a little bit more tricky under 1.9 is if for a non-agency capacity, which is transaction brokerage in the state of South Carolina. And of course, you are presumed to be in transaction brokerage with someone at the point of first substantive contact. So whether you're seeing them in line at Starbucks, at a restaurant, or your initial listing presentation, things such as a buyer's willingness to buy, a seller's willingness to sell, what a buyer would buy a house for, sell a house for, financing terms, or their motivations, that's all kept confidential. So you need to make sure that you're telling people that as soon as you walk into a house, and just say, hey, there's some information. I don't represent you, but if they do for some reason tell you any of that information, you can't then go use that against them with a buyer client later on, even if you never see this particular individual again. So that's sort of to protect you, and it's also to protect the public there. So those are really the number two best things I've seen on Article 1.
Yeah, great point. So what I tell folks a lot of times is, the other agent asks you a question, you're not prepared for that question, you're not really sure if you can answer it or not. One way you can be diplomatic and buy some time, say, hey, that's a great question. Let me write that down for my client, and I'll get back to you. Honesty does not mean you have to answer right on the spot. So kind of as we wrap up here, we'll talk about the ethics process. Austin handles our intake. Austin, can you give like a 30-second overview of the ethics process at SCR, please?
Yeah, so the first thing you should do is always, if there's an issue, try to address it yourself, talking to your broker, maybe having your broker call the other side's broker and try to address it that way. That's going to be much quicker, faster than dealing with us. But if that's not able to work, you give SCR a call. We handle the professional standards for every board in the state except for Greenville. We'll send you a complaint package. Once you get that back to us, it goes to a grievance committee, 5 members of the association, none of them from your local board, that will look at the complaint and ask, is it against a realtor? Is it timely filed? And do the allegations if taken as completely true match up with one of the 17 articles? If it does, we then give you a chance to do some optional ethics mediation. That's where you and the respondent can try to resolve the complaint amongst yourselves with the help of one of our mediators. That's a free service that we offer. Lets the parties sort of be more in charge of the process and maybe negotiate for things like an apology and things of that sort that we're not able to do through our professional standards process. If that does not work or if the parties aren't interested, then we do go forward to a full due process hearing on the merits with opening, closing statements, testimony, evidence, etc. It's usually about 2-3 months from the time we get a complaint to the time of a hearing, unless someone has also concurrently filed with a court or with the real estate commission, in which case we do have to wait for those processes to either be dismissed or reach a final order. If you have any questions on the process, I'm more than happy to answer any of those. Give us a call on the hotline or shoot me an email. I'm austin@screaltors.org, and I'm more than happy to walk through that process and answer any questions you may have.
Excellent. So the one thing to remember, this is called professional standards. So on our surveys, the number one issue with realtors when they're upset at other realtors is a lack of professionalism. So professional standards sets a baseline of professional standards in the industry. And like Austin said, try to talk to the other agent, maybe get the brokers in charge talking to try to resolve it at the lowest level. But ultimately, nothing will proceed unless you file. So unless you file a written complaint, an ethics complaint with SCR, nothing will happen. And the same with LLR on the real estate commission. They don't investigate. The government investigators don't investigate without a written complaint. And we don't handle money except for commission disputes. So if you have a client that wants some money, we typically refer them to talk to their attorney to go to court to seek remedies in that way. And then we also offer mediation to try to work things out. So that wraps up today's top 10 ways to face the ethics. Thanks to Alan for compiling this data. Thanks to Mike for running the video production. And thanks, Austin and Tiara. Any parting words for the members from either of you?
Appreciate everyone's time and attention. And if we can ever do anything to help, don't hesitate to give any of the 3 of us a call.
Tiara?
Yes, and again, if you would like to reach out to me about a fair housing seminar, please email me or call the legal hotline and we can get that scheduled.
Super. Thanks for joining us today and call us anytime. Thanks a lot.
For past and future episodes, check out the Good Life podcast at goodlife.screaltors.org. Thanks for tuning in.